we take a look at the very unfortunate and eminently avoidable confrontation between the University of Delhi and St. Stephen's College. Both are my alma maters. I did my postgraduate studies in St. Stephen's. Actually, in Delhi University, postgraduate classes are all held in university departments. Students are enrolled in colleges. So they are through a college but taught in the university. And therefore, I belong equally to St. Stephen's College and to Delhi University as a student. Subsequently, I joined the faculty of English in St. Stephen's College, and I was an integral part of the University of Delhi for about 45 years. So I know both the setups quite well. I'm also reasonably familiar with the regulation structures of the UGC Delhi University, and I'm also conversant with the provisions in the Constitution of St. Stephen's College. And for about 2.5 years, I worked with the National Commission for Minority Education Institutions, wherein my main focus of expertise was the width and scope of Article 30, Sub-Article 1 of the Indian Constitution, which deals with the rights of religious and linguistic minorities in establishing and administering institutions of their choice. So, in light of all this, I would like to share with you my perspective on this unnecessary, completely senseless standoff initiated by Delhi University. Now, St. Stephen's College, through due process, selected a principal designate. I understand her name is Susan Alias. I don't know her at all personally. It doesn't matter to me. But what does matter to me is the welfare of St. Stephen's College as an institution to which I belonged for about 46 precious years of my life. As all of us will readily agree, the principal of any educational institution, and in particular the principal of St. Stephen's College, plays a very crucial role in shaping the institution, in guiding it to its appointed destiny. Therefore, in making such an appointment, both the management of the college, which in the case of St. Stephen's College is the Supreme Council, which by the constitution of the college is the sole body empowered to either appoint the principal or to terminate the service of the principal. Even the governing body of the college has nothing to do with it. The selection is merely reported to the governing body. So both the Supreme Council and as the regulating authority, the university and the UGC, have a tremendous responsibility to ensure that the functioning of the college is assured to be of the highest quality and the college is allowed to function smoothly and efficiently. Unnecessary, unwarranted interference in the internal affairs of the college must be avoided at all costs, given the fact that St. Stephen's College, from its inception in 1881, has been imagined as a national asset. And I'm proud to say that the institution has carried out with eminent distinction the huge responsibilities cast upon its tiny shoulders. And therefore, India as a country owes a great debt of gratitude to St. Stephen's College. Of that, I don't have the slightest doubt. Therefore, any attempt to cause disarray in the functioning or internal administration of the college, whether it be on the part of the University of Delhi or on the part of the Ministry of Education or on the part of any authority constituted in this country, is not merely a disservice done to St. Stephen's, but also a disservice done to the country as a whole. That's the main reason why I thought I would make my stand known on this issue. Now, as I said, the college, through due procedure, identified a principal designate and announced the matter. And the procedure thereafter is that the matter is reported to Delhi University for taking that into record. Delhi University has absolutely no right to approve or disapprove, to sanction or not sanction the appointment of the principal thus selected. Now, the university in this context is hiding behind Clause 7 of the Delhi University Act, which pertains to the procedural proprieties to be upheld or applied in selecting or appointing the principal of the college. What the university overlooks, either deliberately or by ignorance, is the fact that in a very specific case in 2008, and I had something to do with that case, which is known as St. Stephen's College versus University of Delhi, 2008, and a very distinguished, eminent judge, Justice Muralidhar, heard the matter, and he was so convinced of the case made by the college, and the college was represented by Advocate Romy Chacko, who is a competent lawyer, and I retained him as the lawyer of the college for my entire tenure as principal of the college. Justice Muralidhar was so thoroughly persuaded of the reasonableness and the legal framework of the argument put up by the college that within a short span of a month, which is unprecedented, he gave an emphatic order. And in the interest of clarity, I'm going to read to you just 2 paragraphs from a very well-recent judgment by Justice Muralidhar, who was at that time a judge of Delhi High Court. And I'm going to read to you paragraph 22 and paragraph 26 of this decision or this verdict. The other paragraphs pertain to the circumstances, the arguments put up by both sides, the college side and the university side, university plus UGC. The relevant sections are paragraphs 22 and 26. So let me read out that paragraph, because that one paragraph will make everything clear. And anyone who understands this paragraph will know that the university will cut a sorry figure in assuming this posture of confrontation with St. Stephen's in this particular matter. So here is that paragraph, paragraph 22. You can easily access this judgment. Just go to Google and search St. Stephen's College versus University of Delhi 2008. And you can also add Justice Muralidhar. So here is that paragraph. In the light of the decided cases, is referring to the anterior case law, which applies to this matter. In the light of the decided cases, it is clear that the right of minority educational institutions to appoint the head of the institution cannot be taken away by any rule or regulation or by any enactment made by the state, even if the institution is receiving 100% aid. By the way, St. Stephen's College is not receiving 100% aid. It's receiving only 95% of the approved heads of expenditure, which actually falls short of the actual heads of expenditure. Let's continue with paragraph 22. A law which interferes with the minority's choice of principal would be violative of Article 30, Sub-Article 1. Emphatic, clear, crystal clear. In the Secretary Malangara Syrian Catholic College, the court also clarified that paragraph 72-73 of TMAPI Foundation were not rendered in the context of aided minority institutions, and the same was considered in paragraph 80-55 of the said judgment, which is TMAPI Foundation versus the State of Karnataka 2002, which is a landmark judgment in this case, which actually lays out the law that holds the field as far as the scope of minority rights is concerned. The court also recognized the importance of the post of principal. This is very important. Minority institutions are thus entitled to appoint a person who, according to it, according to the college, not according to the university, who, according to it, is the most suited for the head of the institution. Clause 7.2 of the ordinance, that is Delhi University, which virtually takes away the right of the college to choose its principal, cannot bind a minority administered education. You can't possibly put an issue more emphatically, clearly, unambiguously than this. Now we come to the conclusion, which is paragraph 26. In the result, as a result of going through all the arguments, the pros and cons, in the result, the petition succeeds. The petition was filed by St. Stephen's College. The petition was aimed at, the prayer in the petition was for the court to declare that section 7.2 of Delhi University Ordinance does not apply to St. Stephen's College. So Justice Muralidhar, after examining the various aspects of the argument, comes to the very crystal clear conviction or conclusion that the petition succeeds. It is declared that clause 7.2 of the Ordinance 18 of Delhi University does not apply to the petitioner, which is at Stephen's College, which is a minority institution. The petitioner is directed to proceed with the selection process for filling up for the post of principal, which is vacant since January 2007, and fill up the post of principal within 8 weeks from today. And I have to clarify that it was under the aegis of this verdict that I was appointed the 12th principal of St. Stephen's College. So there's absolutely no doubt left in this regard. And Delhi University is taking an absolutely indefensible, irrational, and unhelpful stand, which it can only discredit itself in trying to obstruct the appointment of the 14th principal of St. Stephen's College, which happens to be a lady, which of course is the first time that it is happening in the history of the college. Now, the fact of the matter is this. When the High Court gives a verdict like this, it applies to every institution and every regulatory body within the geographical limitation of that particular state or union territory, in this case, Delhi. So once the High Court of Delhi, the Delhi High Court, gives such an order, the University of Delhi should have automatically corrected its ordinance. That is incumbent on the university. The university did not do that. Instead, it has now, in a most ill-advised manner, taken a confrontational stand, obstructive stand, irrational stand against St. Stephen's College. I don't know to what extent this is provoked or inspired by the political climate in our country, and therefore I do not know to what extent university may succeed in getting some kind of support from the Supreme Court, because this matter has to now go either to a division bench of the High Court or to the Supreme Court. In light of the framework of law as it exists today, I state once again, Delhi University has absolutely no ground whatsoever in taking the stand it has. And therefore, the university would do well to correct itself and to allow the college to proceed with the appointment of the 14th principal of St. Stephen's College. Now, before I close this video, I want to comment on another subject, which is again something that pertains to St. Stephen's College. Quite recently, St. Stephen's College, again through a process of selection, identified quite a large number of potential teachers. This too has become a matter of debate. The main contention here is that the college violated a particular rule by which, in order to conduct job interviews for teachers, the candidates shortlisted must be in the ratio 1:40. That is, for every post, only 40 candidates who are right at the top of the merit list can be called for interview. Now, there is some rationality, there is some sense in limiting this number, because if you allow, for example, 100 or 200 candidates to be interviewed for one post, interview would become a meaningless exercise. You'll never be able to pay any attention to it, and therefore interview itself will become meaningless. And therefore I can see the sense in limiting the ratio. But St. Stephen's College, for its own reasons, increased the ratio from 40 to 70. And I can also reveal the reason, though I was not a party to it. If the ratio 1:40 is upheld, then many of the Christian candidates would not come within that range. Therefore, the college would in effect end up appointing teachers not from the minority community concerned, whereas the law of the land, particularly the legal scope in TMA Pi Foundation versus State of Karnataka 2002, clearly states the subject to the candidates meeting the minimum academic qualifications as laid down by the UGC and the university, the minority community concerned has the right to appoint teachers with choice from its own community. So therefore, the university's prescription that the ratio of posts to candidates for interview should be 1:40 could in effect render the scope of minority rights null and void. And therefore, the college has a very genuine case or genuine cause in this regard. But there is a hitch. The hitch is this. If the college really felt that this ratio was in effect, if not prima facie, in effect, restrictive of minority rights, the legitimate course the college should have taken was to approach a high court, as was done in 2008 under my advice, and got the High Court of Delhi to declare this particular ratio inapplicable to St. Stephen's College. And in all likelihood, the college would have succeeded. Unfortunately, the college did not take that course. It acted on its own, and assuming perhaps under legal advice, assuming that it has the right in order to select teachers who meet the minimum academic requirements from its own community, and therefore assumed that it was free from this regulation, which I believe is not particularly correct. The college should have approached the Delhi High Court and got a verdict declaring itself exempted from the application of this particular prescription of the ratio. And now, of course, this matter will go to court, and what little familiarity I have with the law in this regard makes me feel that the college has a very strong case, at least 85% strong case. But these days you do not know, from the way things are happening here, there and everywhere, the buffer zone between law and politics is now becoming narrower and narrower and narrower. And judges themselves are not unemotional people. That they too are, as many judges have confessed in the past, they too are influenced by whatever happens in their ambience. Therefore, how exactly this would pan out, I do not know. But I do know for absolute certainty that if this ratio is imposed on minority institutions, the provisions or the laws settled by TMA Pi Foundation versus Karnataka will become meaningless as far as minority education institutions are concerned, particularly in the context of North India. It's not as acute a problem in South India as it is in the North. So there, unfortunately, the college did not follow the right approach, though it has, as I said, the weight of case law in its favor. I again repeat, what the college should have done was to anticipate this problem, as the problem was anticipated in 2008, taken the matter to court, sought clarification on this, then proceeded confidently on the basis of the judicial wisdom obtainable in this matter. So again, going back to the earlier issue, the appointment of the principal, I hope and pray that everything goes smoothly in the appointment of the 14th principal and the transfer of responsibility from the 13th to the 14th would be effected smoothly with dignity and with a positive spirit, and that the college would do well under the stewardship of the 14th principal, Dr. Alias Susan. And I take this opportunity to wish her well. I wish the entire educational family of St. Stephen's College all the very best in the years ahead. St. Stephen's College is a national treasure. Let it be seen and valued, protected and cherished as such. Thank you. Goodbye for the present.